Hello and welcome to everyone once again. We will discuss the constitutional provisions. The constitutional provisions in regards to Karnataka SC/ST Prohibition of Transfer of Certain Lands Act. So, what has been mentioned in the Constitution? What are the provisions? So, the Act under Section 2 it states about the declaration made in Constitution. So, in Constitution under Article 31C. It says Article 31C, it says about the saving of laws giving effect to certain directive principles. So we have fundamental rights that is fundamental to each and every individual, and even against it we have a directive principles of state policy, even though that is also fundamental in the governance of the country. And an individual cannot say that individually his rights have been infringed. He cannot go to the court because of any law. That law should not be made, it has infringed certain fundamental rights. He may go, but if it is the duty of the state to apply these principles in making law, then it is going to be for the benefit of the whole community, the countrymen, maybe in the short or in the long run. So all the directive principles of the state policy to govern the country will not be against anyone's individual rights. Okay, it will be for the benefit of the nation. So this directive principles of state policy are expressly made non-justiciable. Fundamental rights are enforceable by the courts. If anyone's fundamental right has been infringed, then it can be enforceable by the court. The person can go to the court under Article 32, and the courts are bound to declare any law as void, that is inconsistent with fundamental rights. But the directive principles are not so enforceable by the court, nor can the courts declare any law as void which is otherwise valid on the ground that it contravenes any of the directives. It's okay. So there can be certain articles under this part 3 of the Constitution relating to fundamental rights. So notwithstanding anything contained in Article 13 or Article 14 or 19 or a few of those fundamental right articles, so it is declaring that it is for giving effect to such policy made by the government shall be called in question in any court on the ground that it does not give effect to such policy. You cannot go to the court. Again, provided that where such law is made by the state legislature, and the provisions of this article, Article 31C, if it is going to say saving of laws giving effect to certain directive principles, and it is being reserved for the consideration of the president, then yes, the assent of the president has to be taken. So we said about Article 46 under Section 2. So under Section 2 it has mentioned about Article 46. So what is this Article 46? It is promotion of educational and economic interest of SC, ST and other weaker sections. So this is the article which says about the protection of education of SC, ST educational and economic interest. They should not be exploited. That is what this article says, and shall protect them from social injustice and all forms of exploitation. So earlier in the object of this act we discussed about the exploitation. The SC and ST, the people belonging to SC, ST community were being exploited. So that is what the article says, that they have to be protected from the social injustice and all forms of exploitation.